Judge, the plea that I had ready to go, well, everything's ready to go. That Marcus with, I already went over his rights with him, but Amar Hatcher and Calvin Andrew just need to quickly go over his rights, and then I would be ready on and then Joshua Henry is just a probation revocation that we've agreed on. But I just need to quickly pop him too.
Got it. Okay. So,
How you doing?
all right, your colleague is back there. He said some of the people are just from Rice Street.
Yeah, so I have position 2, 3, and 4.
Are here now?
Yes, the other 2 are not here yet.
2, 3, and 4. And people were wondering who the female was. They didn't think there were any females.
No, it's not a few.
Or just someone from ACDC.
Yeah.
Okay. 2, 3, and 4. Ms. Rios needs to chat with 3 and 4. So if she could go back there while we're waiting on Ms. Wood, that'd be great.
Oh, yeah. He worked on it. So your Simpson trying to be like you judge.
Who?
Your Simpson. Go back there.
Let's see. I like it. Good morning, Ms. Simpson.
Good morning, Judge.
Deputy Gordon was liking your background.
That's
I figured you needed more of me.
Yeah. Good morning, sir. Are you Mr. Jones? How you feeling? A little better? Okay, you stay way back there. Ms. Wood is running a little late. She'll be here soon. Probably so.
Okay, I just want to drop this meeting off.
Okay.
I didn't say that. So I mean, basically, so they try to get it. I try to get it. So if I were to do that, then you got to reduce it. No, you want to double this one. I was in the fifty. I'm trying to work with all of them here. But I was just going to do it. I'm just going to go.
Hey. Good seeing you.
Sarah, I will be followed. I really. I'm in position now. I don't think I feel like. I don't
That's how you go, that's just.
Hey, Deputy Gordon,
Yes.
can you check with Ms. Rios? Because we now are ready to roll. Please, thank you.
I've never heard of it. Did you go? Did you work there? Oh, it was you work there? How did you like it? Oh, you here? Oh, 5.
Okay, 5 minutes.
I'll carry up. Okay. Let's do Hatcher first. Quick question on Calvin Andrews' possession of cocaine is only 1 to 3 years, isn't it? I don't think it's 1. Let me double check.
Who would you like to do first, Ms. Rios?
Mr. Hatcher.
All right.
Von Hatcher.
Morning, Ms. Wood.
Good morning, Judge. About Hatcher, the only condition for have to discuss is the stay away from location. He's saying it's his house, but maybe we can put that he has to provide proof that it's his house, a deed or something for it to go back.
Ms. Nelson, are you able to hear us?
Yes, Judge, I am.
Great. Good morning.
Good morning.
Ms. Smith, you are welcome to stay there because we actually have Ms. Rivers here. You can be where you'd prefer to be. So as long as you have that microphone near you, you can be back at council table. You also can be at the witness stand. Sure. We switched it up. It's Ms. Nelson who's virtual and Ms. Rivers who's here. All right, Ms. Rivers, you ready? We're going to get on the record. This is 25 SC 005-404, State versus Hatcher. Mr. Hatcher is here in court with his lawyer, Ms. Rios. Ms. Smith is here for the state. Good morning, Mr. Hatcher.
Good morning, sir. How you doing?
I'm all right. How are you doing?
Blessed, sir. Blessed.
Blessed. Well, good. Mr. Hatcher, Ms. Rios tells me that you are prepared to enter a plea in your case. Is that true?
Yes, sir.
Okay. In a moment, Ms. Smith, who is seated behind you, is going to swear you in and then start asking you questions about your case and about your rights. You need to answer those questions truthfully and completely, but you also need to let me or Ms. Rios know if you have any questions of your own. Will you do that?
Yes, sir.
Great. Then we are going to get started and see where this takes us.
Okay.
Ms. Smith?
Yes. Mr. Hatcher, may you raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Middle two, or just first and last?
Full name
Armand Sanchez Hatcher,
and spell that last name.
Hatcher.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given this morning?
No, ma'am.
How old are you and how far have you gone in school?
I'm 34 and I'm in college right now,
Where are you in college?
Georgia State,
What are you studying?
engineering and business finance. My major is engineering, my minor is business finance, but I'm going back for another 4 years to get my major in business finance.
All right.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Counsel, do you also waive the formal reading of the indictment?
Yes.
Do you also waive any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Hatcher, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 7 years probation?
Yes, ma'am.
Do you also understand that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you also understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with another crime in the future, that this plea may be used to enhance that sentencing, even
Yes,
on a
ma'am.
federal case?
Yes, ma'am.
Are you currently on probation?
No, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or your ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that
Yes.
if you did, you could be charged with another felony offense.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove that you've committed this crime beyond a reasonable doubt, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands these rights that they'll be waiving by pleading guilty to these charges?
Yes.
Mr. Hatcher, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment 25 SC 005405, how do you plead to count 1, aggravated assault, count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies, and count 3, receipt, possession of transport of firearm by convicted felon or felony first offender?
Guilty under Alfred.
Are you pleading guilty because you have decided that this is in your best interest to do so?
Yes, ma'am.
And are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
And do you understand that that has to be done 30 days from today?
Yes, ma'am.
Thank you. Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right, thank you, Mr. Hatcher. Your Honor, if this case were to proceed to trial, the state would show that on June 7th, 2025, Officers responded to a robbery in progress call at 855 Conley Road, Southeast Atlanta, Georgia, and this is in Fulton County. On arrival, the officers met with Mr. Quentin Scott. Mr. Scott informed the officers that the location they were at was his grandmother's house who had passed away, and that they got a call from the maintenance person, the person that does yard work around the house, that there were squatters in the house that did not belong there. Mr. Scott then came to the scene to see who was there because once again, he stated this was his grandmother's house. When he got there, he was met by the defendant. They exchanged words, and Mr. Scott said that the defendant pulled out a gun from his waistband and pointed it at him because he told him to leave his grandmother's house. At that point, the officers then, they were able to detain both the co-defendant and the defendant. The defendant at first said that the gun, he did not have a gun, he did not have a bag, he did not have anything. However, there was a bag recovered from the scene with a gun that matched the description that the victim described the defendant pulling out and pointing at him. Because of this, Your Honor, the defendant was placed under arrest for the charges that we're talking about here today. Those are the facts of the case. Regarding the negotiated plea between the state and the defense, we've agreed to, for count 1, a sentence of 2 years probation. For count 2, a sentence of 5 years probation to run consecutive. And for count 3, we've agreed to a 2 years probation sentence to run concurrent to count 1 for a total of 7 years probation. Regarding the special conditions of probation, we're asking for the defendant to stay away from the incident location. I think there's a concern on if he actually stays there or not. The victim is saying it's his grandmother's house, so we'll need some type of documentation that he actually lives there. If so, he can go to the incident location. If not, we will ask him to stay away from the incident location. Also, to stay away from the victim and no contact with the victim, for there to be a Fourth Amendment waiver for the defendant to complete an anger management course, and for him to have no weapons, no replicas, and to forfeit the firearm that was found in the sentence. And that's all from the state, Your Honor.
All right, two questions for you. Thank you for all that. One, your office filed a recidivist notice. Are you withdrawing that for purposes of the plea?
Yes.
2, you named the victim Quentin Scott.
Mhm.
The indictment says Alante Rochelle, Rachell, is the person who had a gun pointed, I guess, at him. I don't know Mr. Rochelle's gender or Rochelle's gender. So I just want to reconcile that, make sure we're talking about the same case. I think we are. We had a bond hearing and you or your predecessor helped me understand a little bit about Mr. Hatcher's tenuous connection to that location. But I just want to, in my mind, connect the dots and know who it is Mr. Hatcher is supposed to have no contact with. And maybe it's both those people, but you gave a name that's pretty different.
Okay, give me 1 second, Your Honor, I'll confirm.
I will. While you're doing that, good morning, Mr. Milam. How are you feeling? Did you get some sleep? A little bit. So word of advice, don't fall asleep in the courtroom you're going to be in. If you're feeling drowsy, just do a lap down the hallway and then come back in there because you don't want to get tossed out of that courtroom. Okay, I know you did, and you work hard for your family at night, but you said, hey, I'm ready to go with the jury box thing. And it should be interesting enough to keep you going. But like I said, there's nothing wrong with you coming and going quietly and you do a lap or go get a soda that has a whole lot of caffeine in it. Well, okay. So do you know if they're up and running?
Yeah, it's 9:30 now.
Well, hold on, let me just hear from Deputy Green. They're going. All right, so right next door, AD. And stick around till lunch-ish. If you're feeling like, Josh, I really got to go, come back in here and just check with me. But otherwise, if they get to their lunch break, that's enough for you to do your jury box report. All right? Take care. Was that enough time, Ms. Smith?
Yes, the police report mentions both of them, but the indictment does list Ms. Rachel. So, well, that'll be the person we would ask for the defendant to stay.
I'll say both if they were in the mix. If Mr. Scott is in fact the grandson of the person whose name is on the deed or the property, let's just keep bright lines in place. So stay away from Quentin Scott as well as Alante Rochelle. Alante is Elante, and Rochelle, Rachell. All right, thank you for that. I don't think, let me see if we got an answer. We don't have pretrial on yet, but I did read the recidivist notice, which suggests that Mr. Hatcher has 3 felonies from about a decade ago from Gwinnett, all property crimes.
Judge, he is also on probation in Gwinnett with a warrant.
Okay, is he on probation for one of these 3 cases? I'm just looking at the recidivist notice. There's a burglary, a theft, and a theft.
No, Judge, it's for possession with intent to distribute cocaine.
Oh, that didn't make it onto, okay. Do you have a conviction date for that?
Yes, Judge, the sentence date is. I'm sorry, that is correct. I was looking at a different case on the calendar. It is for a burglary. The disposition date is June 2nd, 2015.
Got it. And that's still open and active in Gwinnett, and this situation has generated a probation warrant out of Gwinnett.
Yes, Judge.
Okay, great. Thank you. Ms. Rios, your turn.
Yes, Your Honor. Mr. Hatcher, 34 years old. He currently lives with his wife and they have 3 children, ages 16, 9, and 6. I've been in communication with her. I'm not sure if she's here today, but he is in college. He's, as he said, engineering and business finance. His history was about 10 years ago for the most part. He has turned a new leaf with life. He's not involved in any of that. He's trying to go to school. He's trying to take care of his 3 children. He also was trying to get into like real estate. And so my understanding is that he bought this house. He did not record the deed yet, and he is going to get that done. Hopefully we can get out so he can have access to the house. But the police didn't investigate these other people just showing up saying that's my grandma's house. So how do we know it's that his word versus, and I understand we're not going to trial because he doesn't want to risk it. That's why we're doing it under the Alford plea. But he didn't know who these people are that just showed up at the house that he got and saying that that's his house. Now he's denying pulling a gun on them. That's also a part of that Alford plea. But
there was a gun recovered from a bag arguably associated with him. So there's some evidence for the state that they could bring to bear.
Yes, Your Honor. His also wife was at the scene at the time too.
Okay. She was a co-defendant. It looks like her charges went away, but when you pull up Mr. Hatcher's case, it lists a co-defendant, and that is, I'm assuming, his wife. It's a female, so I'm assuming that's the wife.
Yes, Your Honor. And so I'm asking that you go along with the plea that we negotiated, but also do a behavioral incentive date of 3 years. I think that's appropriate since he hasn't been in trouble since then. And I don't think this situation is like the other situations that he had in his past. And so, yeah, behavioral incentive date. And then also when it comes to the state already addressed this a little bit about the no going back to the location, if he can provide documentation that he owns a location or he is renting or whatever his connection is, that he'd be able to go back because all his stuff is there.
Okay. I'll work through that in a second, but that's helpful. Mr. Hatcher, your wife is Ms. Bush?
Yes.
Okay, and is she out of jail now?
Yes.
Is she taking care of your kids?
Yeah, well, our kids are still in Florida.
Your kids are in Florida? Okay, and who are they staying with?
With her auntie.
Okay, they're all of school age, so they're in school down in Florida.
School.
Got it. And Ms. Bush is up here with you. All right. Do you have any questions about anything we've discussed?
Just like she has said, I don't even know who these people are. I just want you to give me a chance to get the deed registered so I can get back to the property because I do actually own the property. I actually have my money broker's license with Kogo Capital, so I am in real estate. And I have a house that's located around the property from that property. So
okay. We'll see what kind of paperwork you generate. So I'll keep an open mind on that. In the meantime, I do find there's a factual basis for your plea. I understand it's an Alford plea. You're saying it didn't go down the way the police report says. But I think if Mr. Scott and Mr. Rochelle testified to what was in the police report, the fact that a gun was found, A jury could find you guilty. I don't know what they do, but they could, and that's what I need to find. And you're saying, I think it's in my best interest to take this plea. It gets me out, and I don't want to run the risk of going to trial. And the jury says, I pointed a gun at someone.
Yes,
Is that a
sir.
fair description?
Yes, sir.
Okay, then we'll go forward. I do find that your plea is knowing and voluntary. You know what both those words mean, but
Sir.
so we're clear on the record. Voluntary means no one's forcing you to take this plea. Have you decided on your own after consulting with your lawyer and maybe with Ms. Bush? And knowing means you've understood the things we talked about. And I get the sense you did. Is that a fair statement?
Sir.
Okay. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Smith?
Yes, Judge.
And Mr. Hatcher, can we sign the indictment for you indicating your offered plea to the indictment?
Yes, sir.
All right, we'll do that. The state has withdrawn its recidivist notice. So I'm going to sentence you as follows. For count one, I'm sentencing you to 2 years to serve 7 months with the balance on probation. Count two has to be 5 years, has to run consecutive. I'll probate that. And then count three will be 2 years to serve 7 months with the balance on probation, and that'll run concurrently with count one. So it's 7 years to serve 7 months with the remainder on probation. So that's 6 years and 5 months of probation. You will get credit for the time you've been in. And while you're on probation, special condition number one is no contact with Quentin Scott or Alante Rochelle. Sounds like they're strangers to you.
Yes.
Keep it that way. But because they may have a legitimate connection to the piece of property at issue, and can you say that address again, just so it's clear on the record, Ms. Smith? It's on Conley Road. I just don't remember the number.
Yes. Hold on a second. That address is 855 Conley Road, Southeast, Southeast.
Conley Road. All right. For now, Mr. Hatcher, it is a condition of your sentence that you need to stay away from 855 Conley Road. You cannot go on that property. Ms. Bush can go on that property if you've got things there that you think are yours. Of course, if she's trespassing, because for whatever reason, I'm not taking sides, it's someone else's property, she runs the risk of being arrested. But you may not go on that property you may not go on that property. Now, you should work with Ms. Rios. If you provide her with paperwork that she believes adequately demonstrates that you have a right to be on that property because you have a lease or a deed or who knows what, then I will modify your sentence. Okay. But until I modify that sentence, that's not a place you can be. And Mr. Scott or Mr. Rochelle would have the right to call the police and you'd be trespassing. And more importantly, you'd be violating a special condition of your probation. And that would spook me a little bit, that after we had this conversation, there you were at 855 Conley Road. And I'd be inclined to say, it seems like you need to stay in custody because you cannot stay away from this place. So don't until you've got a good paper trail, and we'll have a conversation about it. You're not going to have to guess what's the judge think about it. Either the paperwork will be so clear that I'll just modify the sentence, and then Ms. Rios will give it to you and say, look, there's no stay away anymore. An additional special condition is that you forfeit the firearm that was seized. And finally, you will have a Fourth Amendment waiver, which means probation can search you, your car, your place you're staying, if they've got a reason to think, we just want to check on things.
Yes, sir.
I will set a behavioral incentive date of January 16th, 2029, which is 3 years from now. If all has gone well and you haven't had any arrests and no issues with 855 Conley Road, then probation is invited to reach out to me to say, can we just close this out? Mr. Hatcher is doing great. He got his degree. He's a successful, whatever you are successful at. And we can move on to probationers who are not doing well. Okay? Ms. Smith, anything else from the state?
No, Your Honor.
Ms. Rios?
No, Your Honor.
Do you have any questions, Mr. Hatcher? Oh, one thing I should add, the sentence that I just described theoretically gets you out of jail now because you've done a little more than 7 months in custody. But you've got that hold from Gwinnett.
Yeah.
This will release you to that hold. So in the next few days, you'll be transported to Gwinnett, and then you can deal with business there, whatever they're going to do.
Yes.
Once you and Gwinnett sort things out and you're released, then you're going to need to report to probation.
Yes, sir.
Okay? But I didn't want you to think, great, 7 months, I'm getting out tomorrow. Gwinnett decides
Yes.
when that's going to be. Ms. Simpson, how do you want to handle reporting instructions for Mr. Hatcher?
Judge, he just needs to report to our office. I'm sorry, not our office. Let me back up because I want to make sure he's in the correct one. To the Gwinnett office within 48 hours. Mr. Hatcher, I show you have an Atlanta address. Is that correct?
Yes, ma'am.
Okay, so for now, when you get out, you need to report to the Gwinnett probation office because that's where you already are currently being supervised. But I will get with my superior to see if we can get your case transferred to us.
Yes, I think Gwinnett will transfer it to y'all. I think they wouldn't have no issues transferring it to y'all because I definitely can't go back and forth from Atlanta
Yeah,
to Gwinnett.
that's not a problem. I'll get started on that today.
Okay.
But unless you won't hear from me because you'll be in custody. So I don't want to tell you to report to Atlanta and then they haven't transferred it by the time you get out.
Okay.
So
Yeah, start with Gwinnett and
Yeah.
you can encourage them to make the transfer. Ms. Simpson will be working in the background to make the transfer. But until someone tells you it's been transferred, you got to make the trek up to
Okay.
Gwinnett, okay?
that is
All
correct.
right. Okay, thanks, Ms. Simpson. All right,
Thank
Mr.
you,
Hatcher,
Judge.
good luck with things.
I have one more question.
Yes, sir.
So when I actually get my deed and everything done and everything situated with that house, do I send it to her?
Her being Ms. Rios,
Ms. Rios,
yes.
yes, do I send it
Get
to
it to Ms.
Rios?
Rios because she'll share it with Ms. Smith and with me, and then we'll confer and say, yeah, this is sufficient, or this is a little weird. Why is there a thumbprint of blood on there, or whatever the situation is? And it may be that we have to have a hearing, but the hearing isn't something where someone's going to get in trouble. It just would be me deciding I don't find that to be adequate paperwork. And then you can say, well, what the heck do I need? And we'll figure that out. I'm not a property law expert, but there's clearly some confusion over whose property that is. And it may be that Mr. Scott didn't realize there had been a transaction. It may be that you were fraudulently sold that property. There could be that you are the victim in the property transaction and you're thinking, great, I own it. I gave this guy, Ted Smith, $10,000. But if Ted Smith was a fake seller, then it may be that you have an action against that person, but your deed isn't good. But I don't know. I'm not projecting any of that on there. You've got some paperwork together. You get it to Ms. Rios and we go from there.
Will do, sir.
All right. Thanks, everyone. All right. What I'd like to do next is Mr. Jones. He is looking weary, but Ms. Wood, I need to deliver our superstar Jan term intern to the trial. So I'm going to take her to 7E, just get that situated. When I come back, if we could be ready to go with Mr. Jones, still misdemeanor plea?
Yes.
Should be painless enough. We'll do that, and then we'll pivot to the other folks in custody. Does that work?
Yes.
Okay, great.
Ms. Rios, can you text me a contact number for Mr. Hatcher?
Miss Rockwell, where's your, oh, there you are. Good morning, Miss Rockwell. No worries. Mr. Williams was here to fill my time for
Do you have any contact? I just want to make sure it's the same one, the same information we have. And I'll give you the last four. Let's see.
You can, Miss Sherman doesn't have anything to do with that though.
Last four I have is 4690.
So, Miss Sherman is being an awesome friend of the court. Miss Walton is on vacation this week.
Okay. Thank you.
No, Miss Avery would give it to you. Oh, okay.
Ms. Wood, are we ready? Mr. Jones, can you make it up to the podium? And good morning, Officer York. Thank you for joining us from pretrial.
Yes, sir. Good morning.
Good morning. Do you have the calendar?
Yes, I do.
Excellent. All right, let's get on the record. This is 24 SC 002-181, State versus Duranta Jones. Mr. Jones is here. He made it. Wasn't doing so well last week. Glad you're amongst the walking again. Mr. Jones is represented by Ms. Wood, who is also here. State is represented by Ms. Smith. And we are going to move forward. My understanding, this is a plea, but it's a plea to some reduced charges so that ultimately it's misdemeanors. Is that right, Ms. Smith?
Yes, Your Honor.
Okay. Mr. Jones, Ms. Smith is going to put you under oath in a moment and then ask you questions. You just heard a plea. You know what this is like about your case and about your rights. You need to answer those. You need to let me or Ms. Wood know if you've got questions or you're confused by anything. Will you do that? Okay. And when you answer, make sure you speak loudly enough that Ms. Rivers here can hear you. Okay?
Yes, sir.
Great. Let's get started.
Thank you, Your Honor. First, would you like to know about those reductions?
Sure.
Okay. Count 1 and count 2 will be reduced to reckless conduct. The OCGA code is 16560. Count 3 will be no cross. And count 4 will remain the same.
So it was misdemeanor obstruction?
It will.
Okay. Got it. Thank you.
Mr. Jones, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Durante Devion Jones.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, medicine, for flu.
Okay. But that's just flu stuff,
Yes.
whatever. And you're only taking that because of the flu. You don't normally take it.
No, no.
Is that medicine making you woozy or groggy at all?
No, I just like take it at night and a little tea in the morning.
Okay. But you feel like you are alert enough now to understand what's going on?
Yes, sir. I'm just getting back used to the bright light. That's it.
Okay. We can dim it a little bit if you need it.
No, sir. It's all right.
Mr. Jones, how old are you and how far have you gone to school?
48. I went to the 10th grade, but I got my GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied with client has a full understanding of this proceeding?
I am.
Do you waive the formal reading of the indictment and any knowledge based in the indictment?
So wait.
Mr. Jones, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
We are not.
No, ma'am.
Do you understand that this is a negotiated plea of guilty, which means this is negotiated?
It's
Wording on some part this. Okay. Mr. Jones, do you understand that this is a non-negotiated or blind plea and that the state will recommend to the court a sentence?
Yes, ma'am.
And do you understand that the sentence the state will be asking the court to impose is 36 months probation?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentence?
Yes, ma'am.
Are you currently on probation?
No, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial.
Yes, ma'am.
Do you understand that you waive any and all offenses, including any mental health offenses, by entering a plea of guilty?
Yes, ma'am.
Do you also understand that by pleading guilty, you are giving up the following rights?
Yes,
The
ma'am.
right to
Just wait till she asks him.
Oh, I'm sorry. I thought you.
That's okay. She's going to go through a long list. And as long as you understand all of them, a yes at the end is great. If she says something that you say, wait, I don't agree with that, I don't understand it, we should stop and work through that.
The rights that you'll be giving up is listed as follows: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your wrong and call your own witnesses, and the right to appeal if convicted of these charges after the trial.
Yes, ma'am.
Counsel, are you satisfied your client understands these rights that they'll be waiving by entering the guilty plea?
I am.
Mr. Jones, has anyone forced, threatened, or promised you to get you to enter into this guilty plea?
No, ma'am.
And as to indictment number 24SC002181, how do you plead to the reduced charge of reckless conduct? For count 2, a reduced charge of reckless conduct. And for count 4, willful obstruction of a law enforcement officer.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
And do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe there is an error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that this must be done 30 days from today?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Thank you, Mr. Jones. Your Honor, in this case, for to proceed to trial, the state will show that on December 19th, 2023, officers responded to 845 Haven Street Southeast.
Can you say the street name again?
It's 845 Haven, so Haven.
Got it.
Street Southeast, Atlanta, Georgia. This occurred in Fulton County in reference of a person shot call. When the officers got there, they observed an injured person that had a gunshot wound that was identified as Mr. Jones, the defendant in this case. Officers then spoke with the witnesses. One witness was Rachel Stein, SINGH, who stated that Mr. Jones came to their residence and he appeared to be angry. Ms. Stein, the witness in this case, is the girlfriend of Mr. Jones's brother. She also told the officers that when he came to the scene of Mr. Jones, he was carrying a black handgun in his hand and that he stated he wanted to see his brother. His brother's name is Mr. Robert Jr. Harris. When the officers spoke with Mr. Harris, who is the defendant's brother, he stated that him and his brother had a verbal altercation. And during the altercation, Mr. Jones pointed a weapon at him. At this point, his father, Mr. Jones's father, he was already at the scene because he lived there with the brother. He then got into it with Mr. Jones. And as they were getting into a tussle, the gun that Mr. Jones had went off and it was a single gunshot. At that point, Harris Sr., who is Mr. Jones's father, left the scene. When the officers got there, he did later return, but he was not there initially when the officers got there. He told the officers that he shot his son. However, Mr. Jones in this case told the officers that he did not know who shot him, which the officers later learned to be false. At that point, Mr. Jones was taken to Grady Memorial Hospital, where he was cleared and then transported to Fulton County Jail for the charges that we have here today. Regarding the state's recommendation for this case, for count 1, the state is requesting 12 months probation. Count 2, 12 months probation, and for count 4, 12 months probation, all to run consecutive for a total of 36 months. Regarding the special conditions of probation, the state is asking for a stay away from the incident, for the defendant to stay away from the incident location, for there to be no violent contact between the victims in this case and the defendant, for the defendant to complete an anger management course, and for him to have, to not have any weapons, guns, replicas, or any weapons of the sort. And that's all from the state, Your Honor.
Thank you. Mr. York, criminal history, please, for Mr. Jones.
Yes, sir. I'm showing 27 cycles. I have 3 felony convictions. The most recent was a 2021 APD, the receipt, possession, or transport of firearm by convicted felon. And prior to that, there was a 2014, I'm sorry, it's a 2013 APD.
Who is that address?
It's possession of cocaine. And I have a 2011 APD aggravated assault. Nothing further.
All right. Thank you, sir. Ms. Wood.
Thank you, Judge. Mr. Jones is 48 years old. He does have a 10th grade education. He does have a GED. He has 3 children. Your Honor, he is the victim in this case. As you heard, he still has a bullet lodged in his chest. It's my understanding the state of Georgia never pursued charges against the shooter. We're asking for this to be just a straight time served or suspended sentence. He served a total of 216 days for this case, Judge. Originally, he served, 173 days. So from December 20th, 2023 until June 9th of 2024. And then, of course, he was picked up on a bench warrant, or not a bench warrant.
It was. I was going to ask about, that's one of my queries to you is what was up with the bench warrant? And then it got set aside. So he gets credit for those days. I just was curious what that storyline was.
Sure, Judge. So, and he served 43 days for that bench warrant. So that, I'm pretty sure if I remember correctly, the address that the notice was going to was actually the stay away.
The Haven Street.
Yes.
That's right.
And there was a whole situation because at one point his children were still living there and it was hard for him to manage childcare. It's a whole thing, Judge. So that is why there was a bench warrant, and that is also why this court set it aside for us. So that's our request of the court, Judge. Okay.
You are describing Mr. Jones as the victim in the case. He is, it sounds like by everyone's account, the one who got shot. There's more to the story part from the state, is Mr. Jones shows up at this address mad, he's got a gun, and then there's a tussle over the gun. And as a result of that, Mr. Jones is shot. Are you saying actually Mr. Jones never had a gun and his brother or his dad just hauled off and shot him? Or that's not, you're highlighting the fact that even if Mr. Jones started the disagreement, he paid a higher price than anyone else.
Sure, Judge. I'm not sure how to answer your question. All I know is that if
I can ask
Robert
Mr.
Harris
Jones.
Sr. came back to the scene and told the officer that he had shot his son, I understand that my client told the officers, like, that's not true. Who knows if he was protecting his father and his brother. It's a mess is all I want the court to know.
I got it. It's a mess, and a misdemeanor resolution is the right way. I am happy, if that's the right word, relieved, grateful that no one was more seriously injured. You got shot in the chest and you're still walking. That's great. It's good that your father wasn't more seriously injured, or your brother. It sounds like there's some volatility there. Mr. Jones, that was a while ago, 2 years and a month or so. Was that a situation that involved alcohol, or someone was high, or everyone was calm and level-headed and entirely sober when that happened?
I was home. I stayed there.
Okay, but that wasn't my question. My question was, if I had been there on December 19th, 2023, would there have been alcohol in the mix or something?
To be honest with you, alcohol. I'm assuming because, like I said, I was there and I know I had gonna have me a beer or two sitting at home.
Okay.
But they had just came back.
Your brother and your dad?
I was upset because they left my auntie. I had gone went and took care of my twins.
Okay.
I came back home. They left my auntie. She was 87 and 89 years old.
Okay.
They left her at home alone by herself.
Okay.
I came in the house and she was stuck in the bathroom.
Okay.
And that
so
was,
you're upset. Why do you leave her alone?
Exactly.
And
that's the only thing I spoke on. Well, they
Okay.
saying I had a gun there, Your Honor, they dead wrong. I never had a gun.
Okay. And we will leave that to higher powers to work on in future days. How old are your kids?
3, and I have a 17-year-old girl, and I buried both of my sons, 16 and 14.
I'm sorry. So you have 2 still living?
Still living.
3 still, so 1 is 3.
2 is 3.
Twins.
You have twins. Okay, 3, and you said 17 is your daughter? And then you've buried 2 sons. Okay.
I'm 2 months before I got shot.
Okay. The 3-year-olds stay with you or with their mom?
They're with their mom now.
Okay. Is that in the Atlanta area?
Yes.
Okay. And then the 17-year-old, she in high school?
She graduated.
She did already.
Graduate this year.
She's graduating this year. Good for her. What's she going to do?
She wanted to go for criminal justice.
Hey, Ms. Wood can help her with that. That's good. Where's she going to high school?
Columbia High School.
All right. And she's on track to graduate?
Yes, sir.
Does she stay with you or with her mom?
Back and forth.
Back and
I
forth?
have her 2 weeks. Her mom have her 2 weeks.
Okay. All right. You don't live at 845 Haven anymore?
No one does anymore.
No one? Is it empty house?
I lost it when going through this. I lost it.
Okay. Your auntie is where?
She passed.
She passed. Your dad's still alive?
I don't know. I haven't talked to
You
her.
stayed away from him? All right. And then your brother is your brother Robert Antoine Harris or Robert Jr. Harris?
Robert Antoine.
That's your brother?
Yes.
And then Robert Jr. Harris
My father.
is your father. And it says in there senior. It's Robert Jr. Harris Sr. Do you have another brother named Robert Jr. Harris? Okay, the indictment's got a little senior tucked in there as well. Okay. Anything you want to add?
No, sir.
Okay. Complicated situation. I'm sorry the family dynamics played out that way. What I'm going to do, Mr. Jones, is accept your plea. I do find that there's a factual basis that there was reckless conduct involved. That's what you're pleading to. You're not pleading to you had the gun or your dad had the gun or anything. It's just that things got tumultuous at that house. And then unfortunately, someone got shot. You are not pleading to possession of a firearm. That's being dismissed. And then it sounds at sort of the end of it, you and the officer had some words. You're pleading to that. I'll accept that plea. I find that your plea is knowing and voluntary. Knowing means you've understood what we've talked about. I appreciate you disagree with some of what the state said happened, but you are knowingly disagreeing. Like, I hear what they're saying, but here's my version of events. Is that a fair summary?
Yes, sir.
Okay. And voluntary means no one's forcing you to enter this plea. You're doing it because you just want to move forward. Is that also a fair statement?
Yes, sir.
Okay, I'll accept that. Ms. Wood, can someone in my office sign the indictment on your behalf?
Yes, sir.
Ms. Smith?
Yes, sir.
And Mr. Jones, can we sign your name to the indictment indicating your misdemeanor plea?
Yes, sir.
All right. What I'm going to do, Mr. Jones, on where did you get shot? Where in the?
Right above my my lung.
Okay, and the bullet's still in there.
Yeah, that's the reason they can't. They won't do surgery on the cut from the front because they had to cut my main artery, and she said they won't have time to repair it. I
You bleed out.
and going in from the back where it's sitting there from my back, it'll damage my whole left side of my nerve. So they're trying to wait till it move it away into a place.
Oh, like the bullet may migrate to a safer spot.
That's what they hoping.
Can you feel it? Like it?
Yeah,
Yeah.
every day.
Just, okay. Mr. Jones, I'm going to sentence you as follows. On count 4, count 4, I'm sentencing you to 7 months to serve. You'll get credit for all the time you've been in. For counts 1 and 2, I am sentencing you to 12 months. They are running concurrently with each other, but consecutive to count 3. And they are suspended. The special conditions of your suspended sentence are, number 1, you obey the laws of Georgia, the other 49 states in the United States. And then number 2, no violent contact with Robert Jr. Harris or Robert Antoine Harris. That doesn't mean you cannot be around them. If there's a family thing, you can be there, but you guys can't scrap. If you get a sense things are getting stirred up, you got to walk away. Okay? Now that's a suspended sentence. There's no one looking over your shoulder. You're not going to probation or anything like that. But I'm telling you, if you get arrested in the next few months for anything, the state gets wind of that, they can come to me saying, Judge, you gave Mr. Jones a chance. We are moving you to revoke his suspended sentence. And if you get arrested for something other than like a jaywalking, I'm gonna think about, I may well revoke it. And you'll get a hearing, and Ms. Wood will be there. But you should know that you're still under this sentence for the next year. And the main piece is stay out of trouble. So if that's not hard for you to do, it's a super easy sentence. You don't have to pay probation or anything like that. But if that is hard for you to do, because maybe when you drink a little bit of beer, you get a little angry with folks, then we may be back together and I'll be disappointed and unimpressed, and we'll see how that plays out. Okay?
Don't worry about it.
All right, well, we'll see. Ms. Smith, anything else from the state in Mr. Jones's case?
Yes, I just wanted to clarify, you said that 1 and 2 will run consecutive to 3, but did you mean 1 and 2 will run consecutive to count 4?
I did. Thank you for clarifying that. So it's clear, because Ms. Nelson needs to get this down, and I wobbled by saying 3 at first. It's 7 months to serve on count 4, followed by 12 months suspended for counts 1 and 2. So count 1 is consecutive to count 4. Count 2 is concurrent with count 1. They're both 12 months, and that's suspended. So the overall sentence is 19 months with the first 7 to serve and the remaining 12 suspended. We don't usually talk in months, we talk in years, but you've got misdemeanors. Did that clear it up, Ms. Smith?
Yes.
Thank you. Ms. Wood, anything else?
No, Judge, thank you.
All right, Mr. Jones, go home and rest.
Thank you.
Well, this was fast. Who's this?
This was the next position, yes, what was it?
Cap Andrews.
Andrews, sir. Position number.
Mr. Andrews, number 4. Got it. Thank you.
One second, right?
That's fine. Ms. Rios, are you good to go, or do you need more time?
I'm good to go on him. With Marcus Smith, there's a hiccup that we didn't know about. There's 2 other cases that we want to get resolved with him. One was not on the calendar, so he total has 3 open cases and 1 unindicted case.
Okay, well, we'll come back to Mr. Smith. We've got Mr. Andrews standing right there. And let's work through his situation. So we're on the record. This is 25 SC 000-719, State versus Andrews. Good morning, Mr. Andrews.
Hey, how you doing, sir?
I'm okay. How are you doing?
I'm doing all right.
Good. Mr. Andrews is represented by Ms. Rios here in court, and Ms. Smith is representing the state. And Mr. Andrews, Ms. Rios tells me you are ready to enter a plea in your case. Is that correct?
Yes, sir.
We're going to do that. Ms. Smith will put you under oath, ask you a bunch of questions. You need to let me know if at any point during our conversation you've got questions because you're confused by something or you just want to know more about it. Will you do that?
Yes, sir.
Okay, Ms. Smith?
Mr. Andrews, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, Mr. Lord, here. Please state your true, correct, and legal name for the court.
Calvin DeWarren Andrews.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication you normally take that you haven't been given this morning?
Yes, ma'am.
What do you take medication for, Mr. Andrews?
I have nerve damage. I have got shot in my right leg.
Okay, and do you get medicine at the jail for the nerve damage?
Yes, I get medicine at the jail.
Is it a painkiller or what is the medicine supposed to do?
The medicine at the jail is for my nerve, but for my pain, they don't have that medicine at the jail.
Oh, so you've not been getting the medicine?
I've been getting the medicine. I've been getting one of them, but ain't been getting the second one of.
Okay, but all the medicine you take when you're taking it is for the nerve damage in your leg?
Yes.
Okay. The medicine that you are getting, sounds like you're getting one of two. The medicine that you are getting, when you take that, does that make you drowsy or sleepy?
It helped me sleep.
It helps you sleep. Okay. The medicine that you're not taking, because you're not getting it, does that make it hard for you to understand what we're doing here today?
No, sir.
Okay. And the medicine that helps you sleep, when do you take that?
I take it once in the morning and once at night.
Okay. Did you get it this morning?
Yes, sir.
Okay. Has it made you feel sleepy?
No, sir.
No. Okay. All right. Ms. Smith.
Mr. Andrews, how old are you and how far have you gone to school?
I'm 45, 12th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Andrews, do you remember being arrested for these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a non-negotiated or blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
And are you aware that the state's recommendation is 6 years to serve 1 balanced probated?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentence?
Yes, ma'am.
Are you currently on probation?
Yes, ma'am.
Do you understand that since you're currently on probation, your probation may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial?
We'll talk about that.
Yes, ma'am.
For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you also understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, The right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges. The right to testify on your own behalf or remain silent. The right to present other evidence of your wrong and call your own witnesses. And the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands these rights appear to be waived by entering this guilty plea?
Yes.
Mr. Andrews, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea here today?
No, ma'am.
As to indictment number 25 SC 0000719, how do you plead to count 1, possession of crack cocaine, and count 2, possession and use of drug-related objects?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you also understand that that has to be done within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Andrews. Your Honor, if this case were to proceed to trial, the state would show that on February 7th, 2024, officers with the City of Atlanta Police Department were patrolling the area of Winchester Street, that's in Fulton County, in a marked police vehicle when Atlanta Police Department investigator requested assistance referencing a man sleeping inside of a car. That same car was later announced on the radio that the car was now mobile and driving down Winchester Street. At this point, officers observed the person in the car who later identified as a defendant as not having a seatbelt on or having a seatbelt behind him. Because of this, the officers conducted a traffic stop. Once the officer got to the car, they smelled a strong odor of marijuana coming from the vehicle. Because of this, they asked the defendant, Mr. Andrews, to step outside of the car. When they searched the car, they did find suspected crack cocaine that was confirmed by the GBI lab as 1.089 grams of crack cocaine. At this point, the defendant was placed under arrest and charged with the crimes that are before us today. And those are the facts of the case. Regarding the recommendation from the state, for count 1, the state is requesting 6 years to serve 1 balance probated, and for count 2, 12 months probation to run concurrent with count 1. Regarding the special conditions, the state is asking or recommending for the defendant to complete a drug and alcohol evaluation with treatment if necessary, for there to be a 4th Amendment waiver, and also for the defendant to not have any drugs that are not prescribed to him. Regarding this recommendation, Your Honor, the state is asking for that 1 year to serve based on the criminal history of Mr. Andrews, and also for we believe that there's a high likelihood of Mr. Andrews reoffending, so that's why we're asking for the 1 year in custody. That's all from the state, Your Honor.
All right, thank you. I overheard you chatting with your colleague and with Ms. Rios about statutory ranges. This is not 1 to 3 because of the quantity of, so if it's more than a gram, which this was just barely, then it's 1 to 8?
Yes.
Okay,
Correct.
got it. Thank you. Mr. York, can you please share criminal history information on Mr. Andrews? I know he's got at least 5 felonies. I've looked at the recidivist notice that was filed, and that shows a pretty recent one from 24 and then some older ones. But I'm interested in, number 1, the total number of cycles, and then 2, if you actually count more than 5 felonies.
And I have 21 cycles, and correct, I have probably the same 5 that you had. That's what I'm showing.
Great. Well, then I've got that info. So I think I got everything from that paperwork. Anything else of note from your review?
No, sir.
Okay, thank you.
Yes, sir.
Ms. Rios.
Yes, Your Honor. Mr. Andrews is 45 years old. He's from Atlanta. He has 4 children, 2 of which live with him, ages 10 and 15. Before he got arrested, he was working for Ayers grocery store and restaurant, working some hours. He couldn't work a lot because of his injury, and he wants to go back, but his injury is the gunshot wound has made it difficult to be able to work. He's trying to get disability because of his leg injury. I'm asking for, on count 1, 5 years probation, and count 2, 12 months probation to run concurrent. It wasn't a lot of cocaine from my understanding. And I understand that he had a case in 24, but before that did not have repetitive arrest. And because of that, and this is a nonviolent charge, that's why I'm asking for him to have probation and to waive the fees, since he's trying to get disability and he's going to have some trouble paying for probation fees when he first gets out.
Did you explore with Mr. Andrews the possibility of doing drug court?
We talked about it. We didn't, after discussing it, we discussed it wasn't a good fit for him to do drug court.
And tell me, he can or you can, what about it is not a good fit? There's not a need for it, or it cramps his lifestyle, or?
I don't believe it's a need for it.
Okay. Your sense is that, well, let me ask you, Mr. Andrews. You have 1, 2, 3, 4 drug convictions already. 2 of them are real old. 1 is kind of old, and 1 is not old at all. And now we've got this case. So you are around drugs a lot, and it seems to always be cocaine. Is it your view that cocaine is a business for you? You sell it because it's a way to make money, it's a hustle? Or are you around cocaine because you need it, but you may sell some to support you being able to get some?
At the moment, I was, you know what I'm saying, I was selling, trying to, you know, but that was back in my past. Like, I'm like really through doing it. Like, I was never using. I'm not a user.
Okay. And I ask not because things will get worse for you. I just want to make sure we're providing support so you can make a change. You're 45 now. You're not 21.
That's why I say I don't got too old to be.
You have gotten too old. But I work with people who are your age, but because of the addiction, they can't get out of that line of work, because the way they get their supply is by buying a bunch, selling most of it, and that gives them the money to go buy more so they can have some. I'm not saying that's you. I don't know you. But if you are in the drug business because you are needing drugs for yourself, then you ought to get help, because then it'll be easier to get out of it.
No, I don't need it.
That's not your deal. Okay, understood. I'm gonna take you at your word. All right, what I'm gonna do in light of, let me check one other thing. There was an arrest July last year for drugs. And Mr. Andrews was in jail for 3 days. That was it. And then he got out. Any idea what happened with that charge? Is that a PI case now, Ms. Smith, or it may have been something that went through state court? It was definitely a misdemeanor for the marijuana, but then it was possession of a Schedule II controlled substance, which could be cocaine. And that was a felony charge. He posted bond for it and moved on.
On my end, it just looks like it's an open case, so it's not a PI case. It's, you know, second, I'll look at to see if I can get the case number, but it seems to just be an open case.
Okay, yeah, I guess I can click on the booking number too and see what. There's a PI number, so it's 25 PI 006002. Okay. Mr. Andrews, I find that there is a factual basis for your plea, meaning back in February of 24, you had what you had in your car. And I also find that your plea is knowing and voluntary. Knowing means you've understood what we talked about. Is that fair?
Yes, sir.
No questions about anything? Okay. And that was you're shaking your head no?
Yeah, no, sir.
Okay. And voluntary means that no one is coercing you or making you enter this plea, but you've decided it's time to move forward with this. Is that correct?
Yes, sir.
Okay. And I'll accept the plea. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Smith, can we sign for you?
Yes, Judge.
And Mr. Andrews, can we sign your name to the indictment indicating your guilty plea?
Yes, sir.
All right. Ms. Smith, are you withdrawing the state's recidivist notice?
We are withdrawing under A, but not C.
Okay. Were you aware of that, Ms. Rios?
No. Not aware of that.
Okay. It's already a non-negotiated plea. So Mr. Andrews has the ability to withdraw his plea. But I guess you guys should make sure you touch base. The state is being much more consistent in filing recidivist notice now. And so when I see it in the docket, of course, I need to ask, because if it's not spoken that it's withdrawn, then it's sitting out there. Mr. Andrews, where we are now is if I sentence you to any time in custody beyond what you've already served, and you've done just under 6 months, if you combine the 2 times you've been in, that you are not eligible for parole. So I'm just going to make it up. If I said 7 months, then you do every day up to 210 days. You've done about 160 right now. So you do 50 more days. You wouldn't get out after like 2 for 1 or something like that. You understand that?
Yes, sir.
Okay. And that's just a product of your criminal history. The state filed the right notice for that. Ms. Simpson, is Mr. Andrews on probation right now? And do we need to, assuming Ms. Rios is comfortable going forward with it, handle a revocation?
He is on probation, Judge, but this case does not put him in violation due to it actually happened about the same time.
It's the 23 SC, but he didn't plead to that until March, and this happened a month before.
Correct, Judge.
Whew. Saved by a delayed plea. Okay.
Exactly.
All right. And Mr. Andrews, I wasn't going to change what I'm going to do here. I just would want to match up the revocation if there was going to be one. But this plea and conviction is not a basis for your other probation to be revoked. Ms. Simpson, how much time is left on that other case?
Judge, he has 3 years, 20 days remaining.
Okay. All right. Got it. And no to drug court. All right. Mr. Andrews, I am going to sentence you as follows in light of all the moving parts that we've got here. You had been arrested for and indicted for, but you hadn't yet pled to the case you're on probation for when this happened. So already things in the mix, and you got caught with drugs. While these charges were open, you got arrested again, and it's an open case. It has not been indicted yet for having drugs. You're telling me that's a line of work for you as opposed to addiction-based, and I'm going to trust you on that. But I'm not seeing that you have quite yet disentangled yourself from those kinds of things. And I really want to encourage you to do that, given that you've got a bunch of kids and you're getting to an age where you're just going to be a little less resilient when you and the police have to spend time together. So I'm going to sentence you on count 1 to 5 years to serve 1 year with the balance on probation. You'll get credit for all the time that you've been in. Your sentence for count 2, which is a misdemeanor, is 12 months to serve. It'll run concurrently. That means at the same time as your sentence on count 1. Special condition of your probation would be that you submit to a drug and alcohol abuse evaluation. That's just you meeting with a I don't know if it's a nurse or a subject matter expert, and you'll talk with them and they'll be able to get much more detail about what you drink, what you use, and this and that. And if they conclude that you need treatment, then whatever that treatment is part of your probation. But if it is, as you say, hey, may I smoke a blunt every once in a while? And you didn't say that, I'm making that up, or you drink some beer, you don't need treatment for that. You're not going to get treatment for that. You will have a Fourth Amendment waiver, which means that the probation folks can search you or your car if they have a reason to do so. I'm going to waive your probation supervision fees for the first 6 months after you're back on probation, so you can see if you qualify for disability, and so it's conditional. If you qualify for disability and begin getting disability benefits because of what happened to your leg, then you will not need to pay probation supervision fees. It doesn't make sense to take government dollars to pay the government. But if for whatever reason you don't qualify for disability, then after 6 months, you'll need to be paying those supervision fees.
Yes, sir.
Okay? So that is my sentence that I think is appropriate given all the things I've learned about you, your situation, your criminal history, et cetera. That's different from what Ms. Rios asked for. And we're early enough in this process that I'm gonna ask you to talk with Ms. Rios, because you can withdraw your plea, don't get you in any trouble. It's not gonna get you out of jail, but we could then say, all right, Mr. Andrews said no thank you to this, and then we'll get you in line to have a trial some number of months down the road. But I wanna give you a chance to talk to Ms. Rios about it, because she advocated for one thing and I did a different thing, okay?
Yes, sir.
Any questions about what I've said?
No, sir.
Okay, you and Ms. Rios should talk, and then she's gonna let me know what the plan is, okay?
Yes, sir.
Thanks. So, Ms. Wood, do you have Mr. Niang? Okay, is that person here yet, the person from ACDC? Great, so we can do that, and then I guess Ms. Rios has the rest. We've got a revocation. I don't have any paperwork for that revocation, but I asked Ms. Simpson to see if she could.
Judge, I'm sorry, a petition was not submitted
Okay.
at the time that the warrant was, which was about 3 years ago.
Okay.
So all I have is the warrant.
But if you could just send that around so we're all working off the same thing, that'd be great.
Yes, Judge.
Thank you. And then Ms. Smith, what's the hiccup with Mr. Smith? Was it that people wanted to resolve everything?
Yes, initially, positions 5 and 6 were the only 2 cases we were doing a global for.
Yep.
But Ms. Rios just informed me of another PR case he has and another open case that she would like to do.
Open as in it's been indicted?
Mhm.
Is it in another courtroom, or it just is so new it hadn't hit one of our calendars yet? What's the case number?
25 SC 005122.
It's with us. So we could do, did that mean your offer changed because you learned it's another shoplifting. Did that change your offer? Forget about the PI one for a minute, but if we were to weave 5122 into the mix, was the disagreement like, wow, now it's 3 shopliftings and so it's a different offer from the state, or what?
State offer would change.
Okay, all right. Well, we should keep talking since we have him here and see what we can do. Is the PI case also a shoplifting?
No, it's a violation of cutting off his ankle monitor.
Okay, because that might be one where if he is resolving his 3 indicted cases, the state might say, we're gonna NPGJ that one, if it's a meaningful global resolution. I'm not telling you how to do your business, but we wouldn't necessarily need to hang up 3 pleas over a ankle monitor situation. He did, yeah. Could you spray Ms. Wood too? Oh, that's the like higher power? It's probably what they made at that plant that blew up near your house, huh? I don't know. I just know you guys were quarantined forever after that. He seemed like a very nice guy. He must have been really sick before, because he still seemed a little under. Yeah. I hope they don't cancel each other out, because you were going double barrel there. Like one neutralizes the other. Oh yeah, Mr. Henry should be pretty easy to resolve. Ms. Rios, he's not coming back out?
Well, I was gonna let, we're probably going to trial. I was letting know what his trial date is. What?
It is April?
Okay.
So why don't you, I mean, he can come out, we need to get it on the record, but I'll map all that out for him.
You can bring him out.
Everything all right?
One, I'm gonna use the restroom.
And we're out of TP in there? Come on, sheriff's team. Sheesh, full service.
I'm, out of work.
You pulled rank on him? Like, you get that. Yesterday, when they were making a big deal out of what was back there in the car, I thought that little girl had gotten sick or gone to the bathroom. I don't know if you were here, Joe, the guy brought his little girl to court. And then when it was over, everyone was huddled around the bench there and they were mopping and this and that. And it's cookie crumbs. It was nice they were cleaning it up, but all right, let's get back on the record with Mr. Andrews. Mr. Andrews, I wanted to do some math with you, and then it sounds like you're thinking about going to trial, which is your right.
Just, I just need one more chance, you know. I ain't like, I don't like, I got a family out there. I'm losing everything just sitting there. You know? I ain't no bad person. I ain't got no violent charges or nothing on my record. And like, but
I don't disagree. No one's saying you're a bad person, and you are not someone going out there gunning and running and beating people up. You do keep getting arrested with drugs.
But that's what like, excuse me for cutting you
It's
off.
okay.
But that's what like 2 years ago. I'm trying to better myself. I ain't been getting in trouble for the last 2 years. Like I got probation. I took probation with this case already in hand.
Yep.
You see what I'm saying? Like,
I do, but then I bumped into you getting arrested in July.
that's because
So I don't want you to talk about the facts of that case. Or just, I do, it's important that you and I talk, but if you say, hey, that was my brother's drug, I'm making it up, but you got two prosecutors right here who are, so don't talk about that. Other than I'm observing that you saying I'm all done and that was all a long time ago. And yet here you were getting arrested, and you were at least around drugs because you and drugs and arrest. And I hear you that you want a second chance. One response to that would be, gosh, you already have 5 felonies. So you've had 2, 3, 4, 5 chances. Those sentences.
I did good every time. Like I didn't.
Well, when you say you did good every time,
I have never violated on Judge.
Well, the only reason why this conviction, if you were to plead or if you go to trial and you're found guilty, I don't know what the defense is in your case. The drugs are in your car, but if you are found guilty in this case, the only reason why that's not a violation of your probation is that you happen to have this cocaine a month before you pled guilty in the previous arrest for cocaine you had. But I believe you, and I want to circle back to the first thing you said. None of this is about Mr. Andrews as a scary guy who is eating babies or killing women. That's not the situation. But there are consequences over time for getting busted again and again and again. You heard what Mr. York said, 21 cycles, 5 felony convictions, and it's not productive for a court to say each time, well, you know what, let's just try again. At some point, it is, there needs to be I'm gonna shake Mr. Andrews a little bit so he gets it that there isn't gonna be another time.
I need one more chance.
Okay, well, I'm hearing the words. Let me map out where we are. You're at 160 days right now towards the 360. You will be on a trial calendar that gets you back in court, not the actual trial, the call of the calendar at the end of April. So add another 60, you're at 220. Maybe you get called out to trial. On that trial calendar are murder cases where people have been in jail a whole lot longer than you. So I don't know that we necessarily get to your case, but we probably get to it a couple trial calendars after that. And then you're sort of at 300 days. And your sentence here is 360 days if you go forward with it. And I'm not nudging you one way or the other. I just want to make sure you make an informed decision. Because if you say no, thank you, that's great. I will see you actually 2 more times. At the end of March is your final plea date. That's the last day you could enter a plea if the state gives you a different offer or whatnot, and still have the ability to withdraw. But after that date, then I'd see you at the end of April for your trial. And that's where we are. So I just want to make sure you understood all the moving parts. But Ms. Rios tells me that understandably, you're not excited about the sentence that I imposed and you would rather go to trial. Is that correct?
Yes, sir.
Okay. Then you're withdrawing your plea. I will not fill out the sentence sheet and I will see you on March 31st. That is your final plea date. We'll talk again. Maybe the state will have a different offer or they'll do something with that recidivist notice. But you need to understand that the recommendation they made today, theirs was 6-serve-1. I went a little below that with the 5-serve-1. That's not necessarily what they have to recommend on March 31st. It could be a bigger number. It could be a better number. You understand you don't control that? You understand you don't control what the state offers.
I know.
You know, you've been through this before. Okay. I will see you on March 31st, okay? Thank you, Ms. Rios.
What about the FTA? FTA can't be lifted?
That's something that Ms. Rios can look into and talk to us about later. Today you were here for a plea, and that's what everyone prepared for. And I get why you're saying no thanks. It wasn't what you were interested in. So we'll get you back here and maybe on the 31st, we can talk about the FTA, okay? Ms. Rios, while you were talking with Mr. Andrews, I asked Ms. Smith a little bit about Mr. Smith, not facts or anything like that, but sort of procedurally, where were we? She And Mr. Miller let me know about the other indicted case, which is already ours and actually has been around for a while. I think it just didn't get swept into this calendar. So there are 3 indicted shopliftings, and then there's an unindicted, you destroyed an ankle monitor allegation. So I'm gonna ask you to talk with Ms. Smith about, is there a way to resolve the 3 indicted cases? And maybe if there is, the unindicted case can be put to rest. But since we have Mr. Smith here and he's at least in the plea mindset, and he's done a fair amount of time, waiting to resolve these, if you all would talk about that. We have the warrant for Mr. Henry. That's your revocation. Is that something you guys have already talked about?
We could do that now, it should be pretty quick. I've already talked to him and everyone's on the agreement of what
Great. So why don't we do Mr. Henry, then you all can talk about Smith, and we could do Mr. Niang's. Maybe you and Mr. Miller could talk about Mr. Smith while Ms. Smith and Ms. Wood and I take the Niang plea after we do that revocation.
Yes.
Does that work?
It'll work.
Excellent. Since you're here, good morning, Mr. Henry.
How you doing this morning?
I'm okay. How are you doing?
I'm good.
Good. We're going to get on the record in your case. Your case is 10 SC 92227. It's an old case. You must have been given a mountain of probation.
Yeah, I got a 20 due 10 in 2010.
Oh, so you had a lot of time to do as well. Okay. Well, Mr. Henry, you're still on probation. I'm going to ask, we have a probation officer on this call. She's here virtually. I'm going to ask her a couple questions, and then we're going to dive into this hearing, which sounds like your lawyer and the prosecutor have probably kind of worked things out, but we're going to talk about it in a second. Ms. Simpson, how much time remains on Mr. Henry's probation?
Judge, he has 4 years, 4 months, 24 days remaining.
Okay. And is this the only case for which he's on probation?
Yes, Judge.
All right. Thank you so much. So Mr. Henry, the allegation in the warrant that I signed 2 years and a month ago was that in March of 22, you picked up a new conviction. In Henry County, you were convicted, the dates can't, oh, it's 2 different things. So you had a March 22 DUI conviction in Henry County, and then in June of 23, you had a new DUI arrest. So maybe DUI conviction and DUI arrest?
The arrest was actually, I had to do weekends in jail. And when they book you under the same charge.
You kept getting arrested for the DUI.
They actually got a Facebook page for Henry County. And I was doing my weekend, and people was calling like, man, how you going to jail for DUI every week? I'm like, so, but
Okay.
that's where that comes from.
1 conviction, and then part of your sentence was weekends in jail.
Yes, sir.
Okay. Well, a conviction for DUI is a violation of probation. It was a while ago, and you were, it sounds like, pretty meaningfully sentenced in Henry County. Ms. Rios, is Mr. Henry admitting to the allegations?
Yes, Your Honor.
And 2, what is your recommendation?
To revoke times that he's already served and terminate the balance. And I believe the state and probation are all on the same page with that.
Okay. Ms. Smith, are you in agreement with that?
Yes, Your Honor.
Okay. Mr. Henry, how much time did you serve on the 10 years to serve part of this case?
Served 4 years.
And then you were paroled?
Yes, sir.
So you parole for 6 years and then probation after that? Okay. So you've been in for 84 days so far. Okay. All right. Ms. Simpson, did you get a chance to talk with Ms. Smith and Ms. Rios about this?
Yes, Judge. My recommendation was, as Ms. Rios stated, it was given the nature that aside from the Henry County arrest, the DUI arrest, he has not had any further new arrests since, Judge. So I thought it was permissible to go ahead and terminate.
Sure, because he's effectively been on probation then for over a decade already, if we view the parole as being like probation.
That is
And
correct.
this is the one hiccup.
Yes.
Okay. What was your sentence, Mr. Henry, for the DUI?
2013.
No, for the DUI in Henry County.
I got DUI court. That's
Oh.
it was like drug court.
Mhm.
Which I ended up completing it. It was like,
Well, what was the weekends in jail?
well, it was for the DUI.
So you had weekends in jail and DUI court. How many weekends in jail?
Like 20 something. I can't remember. I think like 26 weekends. Cause they wanted me to do 45 days in jail. But I worked, so they let me do weekends.
Wow. Okay. That's a lot of weekends in jail.
Yeah,
In the Henry County Jail?
sir.
Okay. Well, in light of the penalty you got and the treatment you got for the DUI, and all the other time that you've been on parole or probation and done well, I think this is a reasonable outcome. So I will revoke 84 days of your probation as a result of the Henry County situation, and terminate the balance of your probation. Where is home now? What county do you live in?
Henry County.
Henry County?
Yes.
Okay. What was your Fulton connection way back in 2010?
I grew up in Caperstown.
Okay.
I had, well, I mean, you probably know about all the stuff back in the day.
I do.
But yeah, but
Okay.
I live out there now, so.
You're now in Henry County. Okay. Ms. Rios, anything else on behalf of Mr. Henry?
No, Your Honor, thank you.
Ms. Simpson, do you need me to say anything more for purposes of the revocation order you'll draft?
No, Judge. That was pretty much clear cut.
Okay, thank you. Ms. Smith, anything else?
No, Your Honor.
All right. Mr. Henry, are you still working?
I'm gonna go back to work where I was.
So you think that job is still there?
It should be.
Good.
Yeah.
Okay. All right. Well, good luck with all that.
All right. Oh, is there, I get something like in writing where?
Yes, so Ms. Simpson, that voice you heard, she's with probation. She will send to me today a revocation order. I will sign it today. It'll get filed, and when the sheriff's office does the math, they'll see, oh, look at that, time served, and you'll be released. Will you be released today? I cannot promise you that. But if it is late tomorrow and you're still in, you should be calling Ms. Rios so that we can figure out what the holdup is. And that's assuming you don't have a hold anywhere else. If you're in trouble in Morrow, Georgia, and there's a hold, then that's where you're going next.
Well, I was more about the termination.
Oh, it'll say in there, probation is terminated.
Okay.
And so you can ask Ms. Rios to email you a copy of that revocation order. But part of the revocation order is, all right, after he does his sentence, what's next? And I can say reinstate probation, suspend it, terminate it, and it'll say terminate on there.
Okay.
Okay, and Ms. Simpson is going to let Henry County know that it was terminated. So they communicate internally, but you're going to want that document in case your PO is calling you saying, what's up, Henry?
But I don't have anything for Henry County anymore. I'm done with that. So
Well, so your probation was out of Fulton?
I was on not.
You were on unsupervised probation.
Yeah, and that's
Good.
kind of where, that's the main reason why I want something, because I after I did the court for Henry County, I had a hearing with the chief and probation back then, like in 22. And then they put me on unsupervised, and then all of a sudden, 3 years later, they put a warrant on me.
Yeah.
Or,
Well, it didn't work quite like that. The warrant is old. It took a while for the warrant to find you.
okay, yeah.
So anyway, yes, it'll say on the order terminated.
Okay, cool.
Okay, all right, thanks.
Position number two.
Judge, I'm taking note that the shotgun is on the prosecutor's table.
So I'm taking note that every time I try to put it on your table, and it may even have started there, a certain deputy for security protocol reasons moves it over, but you should know that I can put a sticker on there, equal access. Yeah,
Keep it away from me.
so I put it as close to the defense table as I could. All right, position 2. Can you pronounce your last name for me?
Niang.
Say it.
Nyang.
Nyang.
Yes.
Thank you. We are here on 24 SC 003-384, State versus Nyang. Mr. Nyang is here with his lawyer, Ms. Wood, and Ms. Smith is here for the state. And Mr. Nyang, Ms. Wood tells me that you're ready to enter a plea in your case. Is that correct?
Yes, Your Honor.
Okay. Mr. Nyang, the way this is going to work is that in a moment, Ms. Smith is going to put you under oath. And she's going to ask you questions about your case and about your rights. You need to answer those questions as best you can.
Yes, Your Honor.
If at any time you don't understand what someone says or you're confused, you need to tell me so we can work through that. Will you do that?
Yes, Your Honor.
Okay. Mr. Nyang, is English your first language?
Yes, Your Honor.
Okay. Are you comfortable having this discussion in English?
Yes, Your Honor.
We'll do that. Ms. Smith, when you're ready.
Yes, Your Honor, Mr. Long, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
I'm Nyang.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given this morning?
No.
How old are you and how far have you gone to school?
I'm 26 years old. I've been in college.
Where were you going to college?
This is in New York.
In New York?
Yes.
What was the name of the college?
This was medicine college.
Okay. Where in New York?
This was in Manhattan.
Manhattan. Okay.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Mr. Long, do you remember being arrested on these charges?
Yes, I remember.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
We are not.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court 5 years to serve 6 months balance probated?
Yes.
Are you aware that the court does not have to accept that recommendation and can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal law with any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, I understand.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, I understand.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentence?
Yes.
Are you currently on probation?
No.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, Honest.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, Honest.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you also understand that by pleading guilty, you are giving up the following rights?
Yes,
The
Honest.
right,
She's gonna read through. Wait till she's done, okay?
Okay.
those rights that you'll be giving up by entering this guilty plea will be the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after the trial.
Yes. Honest.
Counsel, are you satisfied your client understands these rights that they'll be waiving by entering into this plea?
I am.
Mr. Long, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 24 SC 003384, how do you plead to count one, entering automobile or other motor vehicle with the intent to commit theft or felony, and count two, willful obstruction of law enforcement officers by use of threats or violence?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes. Honest.
Do you also understand that that has to be done within 30 days from today?
Yes. Honest.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Thank you, Mr. Long. Your Honor, this case were to proceed to trial, the state would show that
Yes,
on
right.
March 7th, 2023, Mr. Nong was banging on the front entrance of the building at 1881 Myrtle Drive when witnesses, workmen saw Mr. Nong jump inside of a car and try to pull off by changing the gear. That car belonged to a Mr. Anthony. That car belonged to a Mr. Odell Workman. At that point, when the defendant jumped inside Mr. Workman's car and tried to pull off, he was pulled out of the vehicle by Mr. Anthony Langford and Sean Butler. At that point, the defendant tried to run away from the scene, but the officers responded to the scene and were able to take him into possession and detain him. At this point, Your Honor, when the officers detained the defendant in this case, he resisted and he also attempted to reach for a taser of the officer Thompson. By doing that, he did scratch her nose and caused her to bleed from her nose. But in that instance, he was still taken to the precinct and he was arrested for the charges we have before us. And those are the facts of the case. Regarding the negotiated plea between the state and the defense, for count one, we're asking for 5 years to serve 6 months, balance probated. And for count two, 5 years to serve 6 months, balance probated. For count 1 and 2 to run concurrent. Regarding the special conditions of probation, we're asking for the defendant to stay away from the incident location, for the defendant to complete an anti-theft course, for the defendant to also complete a drug and alcohol abuse evaluation and attend treatment if necessary, and for the defendant to have no contact with the victim. And that's all from the state, Your Honor.
And when you say victim, is that Mr. Workman? Is it the officer? Is it these folks at 1881? He's already going to be staying away from 1881 Myrtle Drive, but who are you thinking of when you say no contact?
Mr. Workman.
Workman.
Bill Workman.
Okay. And as I'm understanding what you shared, it was actually civilians who pulled Mr. Nyang out of the Honda Civic, whatever kind of car it was. And then police arrived, and they, in an effort to detain him, had this scuffle where an officer had the facial injury.
Yes, Your Honor.
Okay, got it. Mr. York, can you share criminal history, please, on Mr. Nyang?
Yes, Your Honor.
Hey, Ms. Ma'am.
Hi, how are you?
I'm well.
Good. I am showing that there's an open case in Dale County, Wisconsin for battery and disorderly conduct, 8/5/2024. New York for burglary, third degree, illegal entrance with intent, 9/15/25. There's one misdemeanor conviction, Your Honor. I see no felony convictions. You have the Georgia case before you, and again, there's a New Jersey, NY, Wisconsin, so he is a 3-state offender. Nothing further, Your Honor.
How many total cycles across the different jurisdictions?
Okay, across the different jurisdiction, New Jersey appeared to have only one. Wisconsin has, looking at that one now. Wisconsin has 3. One was dismissed, and I see one for New York.
And then this one cycle here.
Yes, Your Honor.
All right, thank you.
You're welcome.
It's a complicated NCIC. Ms. Wood.
Yes.
Mr. Young's been around.
Yes, Judge. So he's 26 years old. This is a 2023 incident. He ended up leaving Georgia when he posted bond, part of the reason he missed court. He's planning to return to New York. I've spoken to a family member there. I don't think he has really any actual family ties left in Georgia. So we've actually been working with PAD. They will help him get back to New York. Of course, the probation component does complicate things. I did explain to him how ICOTS works. He's served 120 days so far, so he's almost at the 6-month mark. We would just ask that you accept the state's recommendation in this case.
Okay. Mr. Nyang, tell me where you view home to be right now.
Yeah. Can you pose me the question again?
Sure. Do you have family in the U.S.?
Yeah, I have family in New York. I'm trying to go back to New York.
You're trying to go to New York?
Yeah.
Okay. To Manhattan?
Yeah, to Manhattan.
That's where your family is?
Yeah, my family stay out there.
Okay. What's in Wisconsin? Why were you in Wisconsin?
My father, he has some family like friends out there, and he sent me out there to have a job, get a job and stuff like that.
What kind of job did you have in Wisconsin?
It was a laundry job, like washing clothes and stuff.
Okay. How long were you in Wisconsin?
For like 2 years.
Did you like it there?
Yeah, I like it pretty good.
Why did you leave Wisconsin?
Cause I was trying to go back to New York and stay with my family.
Okay. What got you to Georgia?
Cause I know some people. I just know some people out here. If they been in Africa. So that's how I know them.
Okay, you know them from Africa?
Yeah, I know them from Africa.
But they were in Georgia.
Yeah, they been in Georgia.
How long were you in Georgia?
I've been in Georgia for like 6 months.
Okay, and well, you were in Georgia for around 6 months when this situation happened?
Yes.
Okay, and then once you got out, you went back to New York?
Yeah, I'm going back to I'm trying to stay with my family.
Okay. Do you have any kids?
No, I don't have any.
Do you have brothers or sisters?
Yeah, I have brother and sister.
How many?
I have one brother and one sister.
Where are they?
They stay in New York.
They're in New York.
Yeah.
Okay. And are your mother and father in New York?
Yeah, they in New York.
Okay. Well, Mr. Nyang, I find that there's a factual basis for your plea, meaning the state could call witnesses and they would be able to talk about all these things we heard about whatever happened in March of 23. I also find that your plea is knowing. That means you've understood the things we talked about. Do you agree with that?
Yeah, I agree.
Do you have any questions about anything we discussed?
No, I don't have any question.
All right. I also find that your plea is voluntary, meaning no one's forcing you or making you take this plea. Do you agree with that?
Yeah, I agree with it.
Okay. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith?
Yes, Your Honor.
And Mr. Neong, can we electronically sign your name to the indictment showing your guilty plea?
Yes, Your Honor.
We'll do that. I understand you want to go back to New York, and we can help make that happen. You have to stay in Georgia until your probation is transferred to New York. And that process can take a few weeks. Do you have a place to stay in Georgia? Or is Pat helping you with that?
Yes.
Okay, so you have somewhere to stay before you go back to Georgia.
Yes, I have choice.
Okay. As he does, Judge.
And where is that place? You don't need to give me the address, but is it in Atlanta? Is it in Macon?
Yeah, this is in Atlanta.
It's in Atlanta. And you'd be staying with friends or family?
This friends.
Okay. And do they know that you'll be staying with them?
Yeah, they know. I'll be in contact with you.
Okay. And they'd let you stay there for a few weeks while you're taking care of the paperwork to get your probation transferred to New York?
Yes, Your Honor.
Okay. Ms. Wood can help you with some of that paperwork, but it's going to be your job to meet with probation and get them what they're asking for. Okay?
Yes, Your Honor.
And until they give you the green light and say, yes, it's been transferred to New York, you need to stay here in Atlanta. You understand that?
Yeah, I understand.
Okay. All right. Well, Mr. Nyong, I'm accepting your plea. I'm going to sentence you on, let me check one thing. Okay. I'm sentencing you on count 1 to 5 years to serve 6 months with the balance on probation. Count 2 is the same sentence, 5 years, serve 6 months, balance on probation. You'll get credit for the time you've been in. So you'll be on probation for 4.5 years. Special condition of probation number 1 is that you stay away from 1881 Myrtle Drive. That's where all this happened. Don't go there again. Number 2, no contact with Mr. Workman. That's whose Honda Civic you were trying to get into. I'm going to require the anti-theft course. That may be something you end up doing in New York. It really depends on how quickly your probation gets transferred. But you will need to do the anti-theft course. And you're going to have a drug and alcohol abuse evaluation where you'll talk with a specialist who will learn a little bit about what you put in you, what you eat, what you drink, et cetera. And if that person recommends any treatment, that treatment will be part of your probation. And it may make sense to have that evaluation up in New York rather than here if it looks like you're going to get to New York quickly enough.
Thank you, yes, Your Honor.
But you understand you cannot travel to New York until your probation is transferred.
Yeah, I understand, Your Honor.
Okay, all right. That's your sentence. Anything else, Ms. Smith?
No, Your Honor.
It doesn't sound like there's any restitution to Mr. Workman for the car or anything like that?
No, Your Honor.
Okay, Ms. Wood, anything else from Mr. Nyong?
No, Your Honor, thank you.
All right, Ms. Simpson, what do you need to hear from Mr. Nyong and what does he need to hear from you?
Judge, Ms. Wood has sent me his New York address. Mr. Nyong, you need to make sure you have a $100 blank money order. Do not fill it out until you report to the office. You need to report to our Atlanta office, which the address is 276 Memorial Drive. That is in Atlanta. It's not far from the courthouse. You need to report to that office within 48 hours after you are released. They will have your address and everything, but there are some other documents that you would need to sign. You need to stay in the state until they advise you that you have been approved to leave.
Okay, I understand.
Nothing further, Judge.
Okay, any questions about any of that?
No, I don't have any question, Your Honor.
Okay,
Thank you.
that's the plan. Good luck, sir.
Thank you.
Good.
Ms. Rios, does it seem like we might be able to sort out Mr. Smith's situation? You're gonna go chat with him? Yes. All right. Thank you, Mr. Miller, for talking with her. Okay.
Miss Nelson, can you either add me to the service or send me a copy of the file disposition?
Yes, I will.
Thank you. Judge, does Miss Wood go to the back?
Yes, she is back there talking to him. Do you need her?
Just could you ask her to check her email when she comes out?
Sure. Check your email, please. Ms. Smith, there is I think it's a paralegal, in your office, last name Haygood, first name Keelan,
Yes.
male or female?
Fail.
Okay, thank you. Give me 1 second and we'll get started.
Speaking.
Yeah,
Okay. This is Mr. Smith.
Yes, sir.
Good morning, Mr. Smith. How are you?
Good morning. I'm well, sir.
Okay, Mr. Smith, you are here on 3 cases, 25 SC 004976, 25 SC 005122, and 5154. They're all shoplifting cases.
Yes, sir.
You have an unindicted case that we'll talk about, I think, as part of this overall discussion. But my understanding from Ms. Rios is that you're prepared to enter a plea in the 3 cases whose numbers I just cited. Is that correct?
That's correct, sir.
Okay. Well, you're here with your lawyer, Ms. Rios. We've got Ms. Smith as the prosecutor for the state. Ms. Smith, no relation to Mr. Smith in this case? Okay. Got to get that on the record. Ms. Smith is going to put you under oath in a moment and then ask you a bunch of questions about your cases and your rights, et cetera. Please answer all her questions.
Yes.
And please let me or Ms. Rios know if you have any questions while we're having our conversation. Will you do that?
Yes, I will.
All right. Ms. Smith?
Yes, Your Honor. Mr. Smith, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, so help me.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Marcus Malik Smith.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, I'm not under any influence of alcohol, drugs, or medicine.
And is there any medication that you would normally take that you haven't been taking this morning?
No.
How old are you and how far have you gone in school?
47 years old. The 8th grade was the highest grade completed, but I obtained my GED in prison in 2007.
Bless you.
Bless you.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, I understand.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment or in these indictments?
Yes, Miss Smith, I have.
Do you need more time to discuss your case with your attorney?
Do we need more time? No. No.
And are you satisfied with her services?
Yes. Great service.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Counsel, do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Smith, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
The only outstanding warrant that I have is a non-extraditable warrant out of the state of Pasco County in Florida. That's pertaining back years and years ago. Only thing I have to do is not just stay out of Florida. It's a case I bonded out on, but that's the only thing. Like if the police officer pulled my name or they pulled me up in Atlanta, that's all it is. Nothing in Georgia.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 1 balance probated?
Can you say that one more time?
5 years to serve 1 with the balance probated.
And this is across all 3 cases?
Yes, they
Okay.
all run concurrent. All 3 indictments.
Okay, yes, I understand.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes,
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
I understand.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes,
Do you also understand that if you're charged with another crime in the future, that this plea may be used to enhance that sentence?
yes, I do.
Mr. Smith, are you currently on probation?
No,
And do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
correct, I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes,
Do you also understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal the convicted of these charges after a trial.
I understand.
Counsel, are you satisfied your client understands these are the rights they'll be waiving by entering into this guilty plea?
Yes.
Mr. Smith, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea?
No,
Okay, you're gonna do this part by indictment, but as to indictment number 25 SC 004976, how do you plead to count 1, theft by shoplifting, count 2, theft by shoplifting, and count 3, simple battery?
guilty as charged on those indictments.
As to indictment 25 SC 005122, how do you plead to theft by shoplifting?
Guilty under that indictment as well.
As to indictment number 25 SC 005154, how do you plead to theft by shoplifting?
Guilty as well.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Correct.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes,
And do you also understand that that has to be done within 30 days of today?
yes,
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
yes, I do.
Okay, thank you, Mr. Smith. Your Honor, if this case were to proceed to trial, the state would show that in the indictment ending in 4976, that on January 1st, 2024, Officer B.T. Walker was called to a Walmart. That location is 4735 State Road 138, where the employees told the officer they had someone that was shoplifting from the store. They were able to detain Mr. Smith after he walked past the point of purchase where he had clothing and food items that was less than $500, was still indicted as a felony because of his previous charges that he has for theft by shoplifting. The other incident, because in this indictment, there are 2 charges for theft by shoplifting. For that second theft by shoplifting charge, this occurred on March 10th, 2024. Officer Johnson reported to a Walgreens location at 4617 Jonesboro Road, where the employees told the officers that they detained Mr. Smith, who was observed concealing dog food in his clothing. When the defendant was confronted, he ran from the store past all points of sale, pushing the employee to the ground. The defendant was then detained outside by the Union City police officers, and they found 29 dog food containers and also 9 large chocolate bars was found on the defendant's person. And those are the facts for the indictment in 4976. For the facts of the indictment ending in 5122, on the state would have been able to prove or show the facts that this would have gone to trial, that on May 8th, 2025, officers were dispatched to a Home Depot location at 2525 Piedmont Road in reference to a shoplifting. When the officer arrived, he was met by the asset protection officer of Home Depot, Mr. Cretan Walker. Mr. Walker told the officer that they observed Mr. Smith concealing things from the Home Depot store and walking past all points of sale. Those items were a Bluetooth speaker, a wireless speaker, outdoor Bluetooth speaker, and a power bank totaling of $152.87. At this point, the defendant is taking custody for that shoplifting incident. And those are the facts of the case with the indictment ending in 5122. In the indictment ending in 5154, the state would have been able to show that on April 16th, 2024, Officer Lockhart was dispatched to 650 Ponce de Leon Avenue at a TJ Maxx location on a shoplifting charge. When the officers got there, they were met by a Mr. Moscova, I'm going to spell that Moscova, who was the protection officer at this location, who told the officers that Mr. Smith was observed taking 5 polo shirts and 1 pack of socks, which totaled to $150 altogether. After walking past the points of sale, Mr. Smith was detained and arrested for the shoplifting incident. And those are the facts of the case of the indictment ending in 5154. Regarding the negotiated plea between the state and the defense, we agreed for a global offer of 5 years to serve 1. And that'll be for each, and I don't know how you want me to break it down, Your Honor.
I can break it down. It's just helpful understanding what your overall recommendation is.
Okay, so that'll be for all 3 indictments to run concurrent. Regarding the special conditions of probation, we're recommending for the defendant to enter into a drug abuse program within 60 days of release. And if the defendant does not enter into a program within those 60 days, he is to come back to the court to
Going to be subject to a revocation.
for a revocation if he doesn't enter into that drug abuse program within 60 days of release. Also for the defendant to enter into an anti-theft course and for the defendant to be gainfully employed. And that's all from the state, Your Honor.
Okay, thank you. I think this is a proper correction, but I'll let you look at the indictments. I think you flipped the facts for 122 and 154. I think that 122 is TJ Maxx, April 24, and 154 is Home Depot, May of 25.
That's correct, Your Honor.
Okay, and I'm familiar with all the facts from looking at the facts as you described them, from looking at the indictments. I think you linked the wrong indictment number to the set of facts, but it is clearly 3 different collections of shopliftings as we move from January 24 to March 24 to April 24, and now most recently May of 25. There is an unindicted case, and we should get that PI number onto the record. Do today's negotiations encompass that? And if so, what's happening to the unindicted case?
Yes, Your Honor. Regarding the unindicted case, that's 25 PI 0036668. The state will be dismissing that charge,
NPGJing it? Okay. And that was an ankle monitor destruction charge?
Yes, it was 2 counts, that one and also local obstruction.
Okay, thank you. There is a recidivist notice in place in all of his cases. Is that something you are leaving in place or amending or withdrawing?
We would like to amend to withdraw from A, but to remain C.
Okay. And is that part of the discussion that you or Mr. Miller had with Ms. Rios?
It wasn't, but my understanding is that he still can get credit for any time that he serves. So
He sure can.
I think that's fine.
Yeah, okay. I think it is a good fit, and I appreciate that tailoring of the recidivist notice. Okay, let me hear from Mr. York. Oh, no, it's Ms. Mann, sorry, I keep forgetting, we transitioned.
Words, Your Honor.
Ms. Mann, the recidivist notice I have shows 6 convictions. So if you have 6 felonies, we don't need to detail those. I've got the facts and figures on the recidivist notice. I would like to know number of cycles. And if you've got more than 6 convictions, I guess I need to hear about those.
Your Honor, there are 18 priors, no more than the 6 felonies, 3 misdemeanors, no FTAs, and the rest was 2023.
Great, thank you so much.
You're welcome, Your Honor.
Ms. Rios.
Yes, Your Honor. Mr. Smith, I think you're familiar with him from drug court because he did drug court initially. Well, he tried to do drug court. He's been trying to get help for himself for years. So this addiction started in 1998. He watched his mom die in a fire. So he was trying to save her and he literally heard her screams and they told him not to go in. He was burned on himself. He said it was a metal door and his skin was stuck to the door. He's used drugs to.
This happened back in 98-ish.
98-ish. So he's
Okay.
a teenager.
Okay, and so the PTSD, self-medication, okay.
PTSD, he also is diagnosed with schizophrenia. So he's been trying to self-medicate. He told me that he takes drugs to stop the screaming of him hearing his mom scream. And so
I'm just saying this when I don't have my mental health meds, like when I do my prescription, do a program and give me the 3 medications I need is Zyprexa, you know what I mean, whatever it is, but when I don't have it, that's what resort me to drug, and that's why I do crime and other stuff, but.
Okay. Mr. Smith, I may have missed it when Ms. Smith was talking with you. Are you getting your mental health medication now at the jail?
I'm gonna have to get it when I get out. They denied me because I have no trace or paper trail to the pharmacy.
Okay.
You know, I was home.
Couldn't show the diagnoses, so they didn't give you the medication.
Yes, sir.
So when was the last time you had any mental health medication?
Like 2023.
Okay. Is the fact that you're not getting that medication making it difficult for you to understand what we're talking about right now?
No.
Okay. All right.
And so that's kind of explains his background of him going back and forth and trying to deal with self-medicating and deal with his mental health. He has goals. He wanted to work. He was working in restaurants when he was not on addicted to drugs and the times that he was doing okay. He worked at Applebee's, he worked at Outback, he worked at Longhorn. So his goal is to go back to culinary school. He was a chef at all those places cooking. So he wants to go to culinary school and work in restaurants. He does not have many communities ties here. He plans to stay here, do the program, and then go up to Ohio, right? Ohio.
Columbus, Georgia, then I will enroll by November, hopefully to Edwin's Restaurant Institute in Cleveland, Ohio, because I did the class in Rice Street. I got my certificate and everything. The only thing I need is 3 reference letters. And when I get finished with the drug class and get my treatment, I can go on. New playground, new place. I don't know nobody, you know what I mean? Because I don't have any family here. That's why I was homeless and doing drugs.
Okay. I don't know about new playground for you, but Ohio may be a good change. We'll talk about you moving out of state in a little bit.
Yes, sir.
But he does want to do the program first. This is a future goal that he's going
Yeah, sure.
to get to. He was accepted to the Salvation Army program, and so they do relapse prevention, AA. He has the weekly meetings. He has to get a job. They do therapy. So all those things hopefully will help him stay out of trouble. I know the offer of 5 serve 1. Most of these are, I mean, I understand of course, these are felonies, but it's because of his history. And it's not like these were petty things that he was doing because of his drug addiction. So I'm asking that you go along with the recommendation for the state, sentence him that if he is released now, he could go to the Salvation Army, but if he has to serve any additional time, we just put it as a drug program. But they are saying that he could come there next Thursday. He has been in a few stints in the jail from May 9th, 2025 till now. And then before that, he was in from November 11, 2024 to April 15, 2025. And then from May 3rd, 2024 to September 10th, 2024. So it looks like he has like a few states, so he might get to that 1 year, should be. So with his background is asking you accept the plea as negotiated.
Okay. I'm kind of on the fence with a plea that doesn't specify the program. And I'm wondering, Mr. Smith, if you've heard about the Metro Atlanta Day Reporting Center, and even if you haven't, if you'd be open to that being the program that I designate. It is drug treatment, it's job preparedness, and they'd be able to help you make sure you are plugged back in with your mental health medication, et cetera. But it would ensure that structure right away, as opposed to maybe I'll do Salvation Army, and the way it's structured right now, you'd need to, or through Ms. Rios, would need to let the prosecutor know that within 60 days you've plugged into a program. But if I make the Metro Atlanta Day Reporting Center the program that you're doing, we all know what you're doing. It's MADRC, and there's not a variable that could lead to confusion, complications. You decide you want to go to a different playground, and then we're back into the cycle that I've seen over the last few years. You wanted to add to that, Ms. Rios?
I've been in touch with Ms. Ross. If by the dates that if he's able to release, that was only, we put that because I initially thought he wasn't going to be released until May, because I wasn't aware about all the other times that he was been in. And so I looked at that and I showed Ms. Smith and I was like, well, he might be getting out, because originally the plan was for him to go to Salvation Army. He was accepted, and Ms. Ross said he can go next Thursday. So if it's by the dates he's able to get out, I can do a transport order to make sure he goes directly there.
So I'm also, like, I'm reluctant to say, let's hope he finds a program. I'm reluctant to rely on the math, not because I think you do bad math, but neither of us is the custodian who will be determining you get credit for this or that. I think you're right, because the oldest case, so if we go back to January 24, the way the statute works now, Mr. Smith would be getting credit for time he served for whatever after that January 1, 2024 arrest. And so if all those things add up to 365, then I think you're right. But it wouldn't be 365 for the case from May, for example. So I don't know how that math is going to work. And I don't think it's safe to say next Thursday, you're going to be at the Salvation Army. And so what I'd prefer to do is say, here's the program you're going to do. So you know exactly where you need to be. And there are no ifs or whats about that. That's just a different program. It's a good program. It works for lots of people. I think it would address some of the things you say you want addressed, certainly drug treatment. It's not going to be chef school, but there is some job preparedness. They want you to be working. And so it could be that you are working as a chef after a while you're still in the program, but it is direct supervision. So I know if there's an issue early on, which is what I'd want to know. But that's not what you all have been talking about. So I'm not trying to rock the boat. I'm just trying to have a sentence that is more concrete, so that we wouldn't get into a debate where Ms. Smith is saying, hey, it was 60 days, you didn't find a program, or you switched up on us, it wasn't Salvation Army because for whatever reason there wasn't a bed, or they make you shave your beard if you're there. You may not want to shave your beard. Tell me what you think about it, Mr. Smith, because you're the one.
I agree totally with what you're saying, because the program, which is the data report center, is a part of the probation.
It is.
First of all, I ain't got to run here, I ain't got to go out. We're going to do everything right here. When you report to your office, we're going to give you the resources right here.
Yep.
When I got to run time, I got to get no butt pain, I got to get no mom, have excuses.
You don't?
Want to be locked up, do it, they give you everything or what. So I agree with that, and that would be lovely, but the thing is, I'm just seeking we get the math together for time, sir, so I can do that and report immediately, 48 to 72 hours. And the 60 days time limit, it'll be automatically computed in with the probation immediately as part of like when I report, I'm into the daily report sitting with the probation. I agree with that. I just want the time, sir, and get out. I'm going through a lot.
We also did a
in jail.
referral to PAD.
Please.
Say that again?
PAD, we also did a referral to PAD.
Okay, yeah, I can't order that. PAD is special, and they will say no thank you to you if I make it a condition of the sentence. So I encourage you to plug in with PAD. They'll help with housing and also some mental health resources. You just walk on in.
Okay.
And you can tell them you've got a case and you're on probation. You want to be real open with them about all your challenges.
Yeah.
They just will not take a case if a judge says Smith has to do PAD.
Okay.
Because PAD is purely voluntary. You can walk away from that anytime.
Okay.
Not so with the day reporting center.
All right.
You can also walk away from it. There are just consequences of that. PAD, there are no consequences if you end up declining the resources that they make available.
Okay.
So here's what we're going to do with sentencing. Gotta track all these cases down. In 25 SC 004976, your sentences for counts 1 and 2 are 5 years to serve 1 year, balance probated. Your sentence for count 3 is 12 months to serve. They'll all run concurrently with each other. So that's 5 serve 1, balance probated. Special condition of probation number 1 is that you enter into and complete the Metro Atlanta Day Reporting Center. Special condition number 2, you take an anti-theft course. They may do that at the Day Reporting Center. You're going to want to ask. You don't need to do it twice.
What if they don't? Because I don't want to pressure me trying to, no, I'm not from here. I don't care what, I'm just saying I need to know where to get to the anti-theft. And because I don't want it in laws where if I'm being forced to kind of, I want the pressure on me. You know what I mean?
Probation will help you find an anti-theft course. It may be part of Day Reporting Center. If it's not, they'll help you find one. So you don't have to worry about scrambling.
Okay, yes, sir.
I'll also ask that, I don't ask, it will be so it's MADRC, anti-theft course. And then I will recommend that probation assign you a mental health probation officer. That's the officer who's just attuned to someone who needs to be taking his meds. And if he's not, they can say, this is what you need to do. They're aware of side effects of medication, et cetera. Hopefully that will assist. And finally, so it's 3 special conditions. MADRC, anti-theft, and you need to take any medication that a doctor prescribes.
Only.
I'm not telling you, only don't take other medication, but if a doctor says take Depakote, you got to take Depakote. And that's a requirement. I'm not saying you have to take a medication, but if a doctor says you do, that's part of your probation.
The doctor's the judge, I get it.
That's right. They know these things. In 25 SC 005122, that's our TJ Maxx and clothes case. Your sentence is 5 years to serve 1 year with the balance on probation, same special conditions. Finally, in 25 SC 005154, 5 years to serve 1 year, balance probated, same special conditions. You get credit for time served in each of your 3 cases. It's my understanding, Ms. Smith, that in light of this disposition, your office will file the necessary paperwork to show that in 25 PI 003668, that will not be presented to a grand jury. Effectively, that case is dismissed. Mr. Smith, I know you want to get to Ohio someday to do that culinary school, that chef school. You should, if that makes sense for you. Know that if you're still on probation, for you to do that, you have to have your probation transferred to Ohio. You don't just snap your fingers. You don't call from Ohio saying, I'm here now, please send my probation with me. You work with probation and say, I have an address, I've got a program, and I'd like to go to Ohio. They do some magic with Ohio, they exchange paperwork, and as long as Ohio says yes, and yours is a pretty low-risk probation, they'll say yes. Once they give the green light, you're free to move if that's what you want to do. But it sounds like you understand that's a little ways down the road. Yeah. Step 1 is MADRC.
Yes, sir.
All right. Ms. Simpson, what kind of instructions do you have for Mr. Smith?
I need to verify, okay, does he have a residence?
No, I think Pad will be helping with that. You're unhoused right now, Mr. Smith? Right, so I don't think there's an address that Mr. Smith can provide.
Okay, so what you're going to do, Mr. Smith, is you're going to report to the Atlanta Probation Office. That is 276 Memorial Drive, and that is in Atlanta, which is about 5 minutes from the courthouse.
Yes, sir. Yes, ma'am.
You need to report within 48 hours. That's within 2 days of you getting out.
Okay. Can this disposition be printed so I can have it?
They haven't been out yet. So
You will get, when you report in, they will give you a copy because you will have to sign your disposition. So you will get a copy of your sentence when you report.
Okay.
Nothing further, Judge.
All right. Mr. Smith, I wish you well in this. It sounds like you understand the steps you need to take. When you are following the medication program that a doctor has set, you don't find yourself struggling where you're needing to steal to support. And I hope that's how it works out for you. We are providing some support with the Form of the Day Reporting Center. I hope you take advantage of that. Just know that if it doesn't and you're back here, then we're going to need to look at getting you drug treatment in a custodial setting, meaning you'll be in custody while you get that. It's called RSAT.
Yes, sir.
Just know that's sort of lurking in the background if this doesn't work.
Well, I gotta make it work. I can't stand it.
All right.
Okay, thank you. Thank you so much.
You're very welcome. Good luck with things. Thank you, Mr. Miller, for having the sidebar with Ms. Rios while Ms. Smith was taking care of the other case.
that is a sale.
Thanks for coming by. We got everything under control. Give me one sec, Mr. Milam. Ms. Rios, anything else?
No, thank you.
Okay. Ms. Wood, we cover all your cases?
Yes, thank you.
All right. Ms. Rios, you want one last chance with Mr. Andrews or he's done?
I will talk to him.
No, we'll see him in March. See how it goes.
Yeah.
Mr. Milam, how'd it go? What's the case about?
White guy who, apparently pushed the block through a window.
Why does it matter that he's a white guy?
I was, it was just, it was a little surprising.
That it was a white defendant?
Yeah, it kind of looked like he'd be a judge or something. It was like.
Who's courtroom?
Next
No, I
door.
wanna go watch.
Okay. He pushed his wife through the window?
Yeah, they got aggravated battery, so.
Yeah. So how badly was she messed up?
Yeah, I guess she said her whole foot was through the window, and they cut her eye and cut her butt, stuff like that. And it's just, they got a big, nice house with 7 bedrooms. So he said, he had a problem, and he gets brought to.
Well, it goes to show domestic violence is everywhere. Crime is everywhere. It's not just in neighborhood X or neighborhood Y. And the police go after the folks who do the bad things. Well, that can be a jury box report.
And the only thing I think that what I had a question about is they had like it's not really about black or white. I just didn't see no black men in the jury box. Like they must have get letters.
So the jury is selected by the lawyers, and when they had the group, they would have had about 60 people in the courtroom to pick a jury of 12 to 14. And the lawyers decide who they're going to strike, who they're going to pick. I'm confident that out of that group of 60, it was men, women, old, black, white, etc. For whatever reason, the lawyers in picking the jury said those are going to be our 12. But the lawyer for the defendant had the same ability to say, I want this one and not that one, as did the prosecutor. But that is a little peculiar. We usually things are about 50-50 when it comes to a jury in most cases. But that's a great observation and something you may want to tell the group about when you're giving your jury box report.
So do I have to write or do I just give it over?
I would talk to Ms. Davis, who is your compliance coordinator. I would talk to Ms. Davis about that. You're good to go. Go home and get some sleep.
Okay, yeah, it was actually quick, but I just think, I think it's probably gonna end up being confined.
Oh, you think they're gonna find him guilty?
Yeah, because he said that, he said.
Oh, he was testifying?
Yeah, he testified.
Oh, you saw the interesting stuff.
He showed her, first he said he showed her bumper, and then she went into the window. Then he said he chest bumped her, and then she went into the window. And then they played the video, he was talking to the police, and he said, I pushed her.
Oh, yeah. Yeah, goodbye.
He's gonna
All
have a
right, be
good,
well.
he's gonna have a good report to turn in.
Yeah,
That's a different experience.
okay, well, take care, see you in a few weeks.
His
Ms. Nelson,
presentation is gonna be so funny.
it is. Ms. Nelson, Ms. Simpson, and Ms. Mann, thank you for your help today. I think we covered everything, and I will see you all, I guess, in a while, after the conference.
Judge,
Thank you, Judge.
Your Honor, have a wonderful day and enjoy your conference.
All right, bye-bye.
Bye-bye.
I sent you a message, Judge.